I will, in the morning, we spoke, the word perception was frequently used, that people's perception is this, people's perception is that. I think it was used more in a diplomatic sense. What they were talking about was reality and not perception. And I think let's talk about reality now. Okay? Let's talk about the reality as it exists. I mean, I'm very happy to be in Delhi today because such a meeting we could not have organized it in Bombay or in many other parts of the country. Because the moment we try to organize a meeting in any of those, and it may be Bombay, it may be Ahmedabad, various other parts of the country, the police will put pressure on the organizers and they would give some excuse and they will tell us not to have a meeting. So in a public hall, it becomes very difficult. So the only people we are left with are our Jesuit friends who are bold enough to give us their halls to organize meetings despite there being pressure from the police. But that is the situation of civil liberties as it. Here also, I'm sure it happens in many other places. There was a case in Delhi High Court which reflected that, I think, where participants' names had to be given and all that. So I think that's the level of civil liberties which we are talking about. Let me just talk about 2 or 3 issues because there is a eminent panel, co-panelists with me. They will also be talking about a number of things. Let me just talk about 1 or 2 things. You know, we are at a situation, we are at a juncture in our country right now where authoritarianism bordering on fascism is already existing. And one of the hallmarks of any authoritarian government is not to allow anybody to dissent. Dissent by voice, dissent by assembly, dissent by protest. That's a hallmark of any authoritarian government. And it is in those times that one expects the Supreme Court, which is the guardian of these rights, to immediately step in and say, sorry, nothing, no more. This is what happened post-emergency in the sense that you had a whole new jurisprudence being set up, public interest litigation, rights of prisoners. I mean, PIL started with rights of prisoners. Hussain Ara Khatun was referred to in the morning. Similarly, various other, Sunil Batra, Charles Sobrach, etc., those cases, bonded laborers, the whole jurisprudence changed, court accepting letters petition, court setting up committees, court setting up, issuing guidelines for various, to protect against various human rights violations. This is what happened post-emergency. To what extent it was successful is a matter for another day for debating, but at least the intent was there. Today we see a complete lack of intent of that kind of on part of the Supreme Court, including, I would say, the Chief Justice of India. A complete lack. Look at the situation. I mean, just let me tell you one or two instances. Take UAPA, for instance. In order to crush dissent, one of the easiest way which the government has found is to use UAPA. You arrest people. Earlier, okay, UAPA, anti-terror laws were also used. Now they are used much more, and the bail provisions are being interpreted much more stringently by the courts than they were ever before. So you have a large, and half the people who are arrested today under UAPA are not arrested because some incident happened. Okay? Take for instance Bhima Koregaon case. Nothing happened. Stan Swamy was not charged with having bombed some place. Gautam Naulakha is not charged with having set up a landmine somewhere. No incident happened. So you have a situation whereby people are being put in prison not because of any incident which has happened, any bomb blast which has happened or something like that, but because they fear, because there is an apprehension that these are either jihadis or urban Naxals, the two standard clauses. And what is the Supreme Court's response? First of all, it comes out with the classic, locus classicus called Vatali judgment, which basically takes away all the rights of any accused under the UAPA Act to be released on bail, given by Justice Khanwilkar. Khanwilkar has many more things to his credit, I will come to them. Okay. So that is one thing, Vatali's judgment. Supreme Court tried to push back a little. Najib's case, for instance, saying that if you have spent that right to speedy trial is also a fundamental right. If you spend much more, I mean, if you have spent substantial time in jail, then you should be released on bail, irrespective of what the allegation against you are, provided the trial is going to take a long time. You had some judgments like in Anand Teltumde's case or Vernon Gonzalez, Arun Pereira's case, Tawa Fasal's case, etc., where people were released by using a mix of both these aspects. And then what happened day before yesterday, or 4 days back? You have this judgment which says that as far as these kind of laws are concerned, UAPA is concerned, it's not bail but jail which is the rule. I mean, how proudly they say it, how proudly they proclaim to the world. Okay, this is what Supreme Court of India is going to say, that bail, jail not bail is the rule. Okay? And look at the consequence of that. 3 days back, a sessions court rejects a bail of a person who has been in jail for a long time with a novel argument. When it is said that this trial will take a long time and and he has spent about 4 or 5 years in jail, why are you not releasing him? A novel argument that look, he has been charged with 4 different offences. Everybody gets charged with 4 different offences. I mean, anybody who is charged in UAPA is always charged with 4, 5, 10 different offences. Look, he has been charged with 4 different offences, and it is possible that under the Criminal Procedure Code, there is a possibility that once he is found guilty, the sentences might run not concurrently but consecutively. So the total amount he might have to spend in jail might be 40 years, 50 years, 60 years, we don't know. So how can we release him on bail? Now this logic is going to catch up. And this logic is going to catch up, and this is going to, go on. Same thing with PMLA. I mean, everybody, see, look at the situation that today the Supreme Court in Capital Bonds case says that we have to take judicial notice of the fact that money is used extensively in elections. They actually say that, observe that in the judgment, that we must take judicial notice. Why can't you take judicial notice of the fact that UAPA is being misused? Why can't you take judicial notice of the fact that PMLA is being regularly used? Why can't you ask? Why do you have to always bow down to what the Solicitor General of India says? Even though he is not even a constitutional post. Solicitor General is not a constitutional post. And anytime somebody raises the issue of Kashmir, he jumps up and says, oh, we know who they are acting on behalf of. They are acting on behalf of our neighboring nation, etc., etc. And the judges don't have the gumption or the guts to haul him up. They don't have the guts to tell him that, Mr. Solicitor, just sit down, shut up and sit down. That's what should be done. In USA, you have, the Supreme Court is known by the Chief Justice, Roberts Court, Warner Court, Rehnquist Court, etc., etc. Today, the Indian Supreme Court should be known as Tushar Mehta's Court. Yeah. That's the kind of situation we have come to. That's the situation we have come to. And nobody has the guts to call him out and say that enough is enough. That's the, look at the situation. And in that kind of, repeatedly, I forget about this issue, but repeatedly, Supreme Court says that Look, people are not convicted, especially in sensitive matters. And sensitive, I mean political sensitive matters. People are not convicted because the investigation has been botched up. Repeatedly in judgment after judgment, you will say, Supreme Court saying the investigation has been botched up. Why is not a single policeman who has botched up been taken to account? Why has a single policeman not been hauled up? Why has a single policeman not been sent to jail? If repeatedly you come to the conclusion that these people have botched up, instead, what does the Supreme Court, led by Justice Khanwilkar, does? First of all, any whistleblowers or civil society activists who are trying to help people, who with total boldness approach the court for years together, use the legal mechanism to bring justice to the people who are either tribals or who have been, who have been victims of communal riots. What does the Supreme Court do? Send Teesta Sakalwat to jail? Send Himanshu. Himanshu was here somewhere. I don't know where he is. Is there? He was there. He is gone out. I think he doesn't want to be part of this. Send Himanshu to jail. Boldly, of course, Himanshu says, I am not going to go to hell. I am not going to pay the fine. That's the kind of bold people we have with us. But these are the people who should be celebrated by Supreme Court. Instead, the Supreme Court says, send them to jail. I mean, what have we come to? What kind of civil liberty protection we'll get? Okay? Unless there is Supreme Court. And I personally feel that change only can be brought about by people outside. Look at what is happening. Even in Pakistan, people were protesting about concerning the Supreme Court on the streets. In Israel, when they tried to do the appointments, the appointment procedure was to be changed. Millions of people came on the street. I, of course, wish that millions of people would come on the street in Israel supporting Gaza, but that's a separate issue. This is what is happening in other countries. Here also we need to put pressure, because these things are not going to change by somebody's conscience suddenly awakening on one fine day. This can only change through pressure. This can only change through street pressure. Okay? We can keep on arguing jurisprudence till the end of our lives. Okay? But unless we are there on the street protesting against what is happening, coupled with, of course, fights in, because judiciary is a space we cannot give up. Other side may want us to give it up. We don't want to give it up. It's a space provided to us by the Constitution. We are going to use it. But using the judiciary alone is never enough. Courts are never answer to all your problems. I always believe that major changes come through street battles, not through courts. And that's what we have to focus on. Besides focusing on what is happening in courts, besides fighting out, besides taking, look at the situation. I mean, I have various questions. In courts, out of politeness, you don't ask the judge a question. So you say, I ask myself a question, which is a euphemistic way of telling the judge that I'm asking you a question. Okay? But that is how we do it in court, that I ask myself a question. So let me ask myself a question, one or two questions. Okay. First question, habeas corpus means produce the body. That's a literal way that you produce, you get that person to the court. Okay. If somebody has been kidnapped illegally, detained illegally, you bring that person to court. When it comes to Kashmir, habeas corpus means you go to the body. Okay. You go to Kashmir. You go to Kashmir and you meet him, but don't say anything else. Your freedom of speech will be restricted. Your right to assemble, right to protest is not going to be given to you when you go to Kashmir. What is this going on? Supreme Court saying this. Look at Hadia's case. Finally, of course, Supreme Court had no option but to allow her to go with her husband, because she came to court and said yes. But even then, at the end of it, a bench which included Chandrachud, okay, says that NIA should continue investigating in this love jihad. What basis? What is the basis for saying all this? I am not even talking about Gyanvapi and Ayodhya and all that, because I mean, what do you talk about them? You know, what do you say about them? But look at this kind of a situation which is happening, where for a habeas corpus, when it comes to internet ban, what is the highest the Supreme Court does? It sends the matter back. Supreme Court doesn't set it aside. When in Pegasus case, the Union of India refuses to file an affidavit despite repeatedly being called upon by the court. If a private citizen had refused to file an affidavit, what would the court have done? Court would have heard me up for contempt, or the court would have said that I am making a presumption against you. Okay. What does the court do? No, they don't want to file, they don't want to file. What can we do? You know, now, this kind of a helplessness in front of the executive was never seen earlier. It is something which has happened in recent times. And I feel I'll end by that I think civil liberties are as much under threat from the Supreme Court as they are from the executive. So let's all jointly try and fight it. That's it. Thank you.